We have an update in the Trump trial, the criminal trial that was filed in the Southern District of Miami, Southern District of Florida. Um, I want to welcome everyone joining, whether you're watching live or watching on the replay. All of the views, the comments, the shares, and all that good stuff. If you would like to join the conversation, feel free to enter a comment in the live chat. Um, or if you would like to actually join the conversation and be on screen, follow the link in the description, and that will actually put you on screen. If you're not ready for your close-up, you can turn off the camera and you can be on screen as audio only. So you have different options for sharing your thoughts, joining the conversation. But everyone is welcome. All opinions are welcome. This podcast is not for me to tell people how to think or how to feel or what to like or what to do. The purpose is to bridge the gap. So today we are talking about the update in the Trump trial. District Judge Eileen Cannon has issued the pretrial order, which sets the trial date. And what we're going to do, I want to move me that way. No, that. So I'm going to be off the screen for a second as I read through the order. If you have any questions as I'm reading through, feel free to put them in the comments and I will address them as they come up. So just to start at the top, United States District Court, Southern District of Florida, West Palm Beach Division, United States of America versus Donald Trump. This is the omnibus order setting the trial date and establishing pretrial instructions and sentencing procedures. Now, this is standard. Whether you've got a civil case, a criminal case, judges will oftentimes issue a pretrial order. And it just lays out the basics. Because no matter what court you're in, whether it's a municipal court, a state court, a federal court, they all have rules for how the cases play out in court and just the standard procedures. The jury has procedures. If there's a jury, the judges have procedures. So this is a standard pretrial order. So the first thing that it does is that it sets a trial date. Now, it says here, this case is hereby set for a criminal jury trial during the 2-week period commencing August 14th, 2023, or as soon thereafter as the case may be called. Now, this does not necessarily mean that this case is going to go to trial on August 14th. Many courts have what's called a trial term. So that's what this 2-week period is. It's the trial term that starts August 14th. So this may be the only case on the docket for the term. There could be multiple cases on the court's docket for this term. And then it says a calendar call will be held at 1:45 p.m. on August 8th, 2023. So the week before. And what a calendar call is you have your trial term, you have the number of cases that are on the court's docket for that trial term. And then a week before, everyone that has a case on for that trial term will appear at the calendar call. And then what the clerk will do is the clerk will read through all the cases on the court's docket for this 2-week trial term. And each of the parties in those cases, and usually it's just the attorneys, unless somebody is appearing, on their own behalf, you get up and the court will say, like, okay, is everybody ready? Is everybody here? Are we proceeding? Are you ready to proceed next week? And it goes through case by case. So, and if you're not ready, why aren't you ready? Um, so that's just what the calendar call is, and it's just to see what cases are ready for trial and, and that sort of thing. And it's just like almost like a clerical step for the court. And then it gives the courthouse. So this will be at the Fort Pierce courthouse, federal courthouse. And it says, with modifications to be made as necessary as this matter proceeds. And that I would hazard a guess, it's just because of the nature of this case and who the main defendant is. It's just if they need to make any changes, it's just giving the intro to that. Any testing of electronic equipment to be used at trial must take place at the calendar call. To that end, the parties are directed to bring to the calendar call any equipment intended for use at trial. So that just means anything. If you're using, you have laptops, or depending upon how the exhibits are going to be presented, that's all going to be tested out at the calendar call, just to make sure that everything works, and that, once this is called for trial, everything's ready to go. All pretrial motions and motions in limine must be filed by July 24th, 2023. So, motion in limine is Latin because attorneys love Latin. It just means at the start. So it's before we get started with the actual trial. And usually a motion in limine, and this is generally speaking, I'm not an attorney, this is not legal advice. Motions in limine will usually seek to limit evidence that's that is going to be presented at the trial. Pretrial motions, that could be any, sometimes you may see a motion to change venue. You could see a motion to dismiss. Pretrial motion just means any motion filed by either side before the trial takes place. And all of those motions must be filed by July 24th, 2023. So it gives both sides a little over a month to get their motions filed. There may also be, a motion for extension of time. Sometimes you'll see, where it gets down to the wire and, oh, we need more time, judge. The complexity of this case, we can't get this motion finished, within 30 days. So we need an extension of time to file the motion that we want to file. We could even see there could even be some type of motion like that. Absent leave of court, each party is limited to filing one motion in limine. If there is more than one defendant, defendants shall file a combined motion unless a clear conflict of position exists, in which case the parties shall explain that conflict in their individual motions. Motions in limine may not, without leave of court, exceed the page limits allowed by the rules, and they must state with particularity the evidence at issue and the legal and factual basis relevant to disposition of the motion. So this just means that each party has one motion in limine. So, if there are 6 pieces of evidence that the defense does not want entered, and they want the court to, to strike that evidence, they can't file 6 motions. They have to file one motion. And with there being a second defendant, unless both sides agree on the reason for not including a particular, and what I mean is both defendants agree, on the reason for not including a particular piece of evidence, then they would have to file a separate motion. And, talking about the court rules, part of the court rules do sometimes extend to page limits, so you can't just file 100 pages of nonsense. A lot of courts will limit the number of pages that a motion can be. And then if you want to go over that limit, you have to file a motion with the court, asking for permission to go over the page count. So you can have motions on motions on motions. And let's see. It is further ordered as follows. All requests for writs ad testificandum, which is not condom, must be filed no later than 14 business days prior to the first day of the scheduled trial period. So 2 weeks before August 4th, or 14 business days prior to August 14th. And a writs ad testificandum, again, Latin. These are court orders that require a person to appear in court and give testimony. And then, in accordance with Local Rule 88.5, the parties shall file speedy trial reports every 21 days following entry of this order until the time of trial or plea. And as I was talking about local rules, this line references a local rule. Where it references speedy trial reports, the Sixth Amendment to the Constitution gives criminal defendants the constitutional right to a speedy trial, among other things. And there is actually a Speedy Trial Act, where it talks about scheduling trial within 70 days of either in this case, the indictment and Trump's appearance. Now, it does have in the footnote up here that the other defendant, Walt Nauta, is scheduled to be arraigned on June 27th, and then order setting trial to follow. And paragraph 3, all responses pursuant to the standing discovery order and or local rule 88.10 shall be provided in a timely fashion in accordance with the dates scheduled by the magistrate judge. Non-compliance with the standing discovery order, the local rules, or the federal rules of criminal procedure may result in sanctions. Any notice submitted pursuant to Federal Rules of Evidence 404B must be filed as a motion, not as a notice, and must identify with particularity the evidence to be introduced and the factual and legal basis supporting admission. Responses to such motions are due in accordance with the standard timing requirements set forth in Local Rule 7.1C. Now, where you see, local rule or federal rules of evidence 404B, what you can always do is just Google those. If you're like federal rule of evidence 404B, that tells me nothing. I don't know what that means. So really all you have to do is just Google it. Federal rules of evidence 404B. So let's see. And we'll flip over to, this is Federal Rules of Evidence, Rule 404, which is character evidence, other crimes, wrongs, or acts. And then we will scroll down to B, other crimes, wrongs, or acts. And then this talks about, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Notice in a criminal case, so where it was 404B, where it's talking about the notice. In a criminal case, the prosecutor must provide reasonable notice of any such evidence that the prosecutor intends to offer at trial so that the defendant has a fair opportunity to meet it. Articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose, and do so in writing before trial or in any form during the trial if the court, for good cause, excuses lack of pretrial notice. So basically, if there's evidence of Trump or Walt Nauta committing another crime, it can't be used in this case to prove that they're guilty in this case. If there is another, we do have permitted uses. So if that evidence shows, will lead to like motive, or, that he knew something, or one of them knew that they weren't supposed to do something, or, you know, the prosecutor has to give notice that they're going to introduce this evidence. And, this order says that it can't just be a notice, it has to be filed as a motion. And you have to state what you're going to introduce and why you're going to introduce it. And paragraph 4, to the extent required by local rule 88.9A, all motions shall be accompanied by a written statement certifying that counsel for the moving party has conferred with opposing counsel in a good faith effort to resolve by agreement the subject matter of the motion. That's standard in a lot of courts. Sometimes you'll see it. I know Pennsylvania has it in certain counties, in the civil courts, where it's called concurrence, where you're basically sending your stuff over to the other side, and this is what we're going to file in court. And if we want you to do something and you haven't done it, and now that's why we're filing a motion, let's see if we can work it out so that I don't have to file a motion. But if we don't work it out, I'm filing this motion. 5, counsel shall be prepared to conduct limited voir dire following the court's questioning of the panel. Prior to calendar call, so before August 8th, each party may file no more than 10 proposed voir dire questions, including any subparts, for the court to consider asking of the venire. Not quite sure. I've never seen that word before. Let me make sure I am pronouncing it correctly. I don't like to. No, I don't want that. All right. I know it just means the prospective juror. So voir dire or voir dire, if you are a My Cousin Vinny fan, that is just the process of going through prospective jurors. And it was also referenced in the scene where the prosecutor asked Marissa Tomei the trick question. Let's see. The court will not permit the backstriking of jurors. It's part of 5. And that is just a peremptory challenge used to strike a prospective juror after the juror has been accepted onto the jury panel, but before the panel has been sworn. So that's another thing. both sides, the prosecutor and the defense, they will have preemptory challenges, which is just, it's Tuesday, get out, or challenges for cause, where, if somebody stands up and is like Trump 2024, and I don't care what you say, I'm not voting to convict Trump. That's going to be like, that person is clearly showing that they can't be impartial. Um, so that can be a challenge for cause. Or if somebody says, I'm Trump's cousin, if you're related to any of the parties, you can be struck as a juror. But it's just saying, uh, in that process, that once they get through voir dire and the challenges and they've got their 12 people, and whether there's going to be any alternates or not, I don't know. But once they have the jury set, but before the jury takes their oath, you're like, neither side is allowed to go back and say, oh, you know what, I still have 3 preemptory challenges, so I want to get rid of, these 3 people. It means when that person comes up to be reviewed to be a potential juror, that's when you use your challenge. You can't go back and try to challenge after the fact, after they've been accepted as a juror. Sorry, dropped my pen. 6, prior to the calendar call, the parties shall submit in Word format via email proposed jury instructions, including substantive charges and defenses, and a proposed verdict form. And then there's a link for instructions. Sorry, on filing those documents. And then this tells them, how to submit the proposed jury instructions and the verdict form jointly. You have to include your citation for authority. And then where the parties don't agree on a proposed jury instruction, they have to put that in bold. And, on the prosecutor's side, their instructions, where it's contested what the instruction should be. The government's proposed language should be underlined, and then the defendant's proposed language would be in italics. And, so this is just about how to put together the jury instructions and the verdict form. And then also, prior to the calendar call, this is paragraph 7. All counsel shall file lists of proposed witnesses and or exhibits to be presented at trial. All exhibits to be offered into evidence must be relabeled in accordance with the proposed exhibit list. And then this gives how the, prosecution exhibits are to be designated, GX1, GX2, and then the defense exhibits are DX1, DX2, et cetera, et cetera. Counsel should take care to ensure that exhibits are not compound. That is, that each document, to the extent practicable, is identified and marked individually. So, just don't have like 15 pages of different things put together as one exhibit. They should be separate exhibits. Paragraph 8. Additionally, no later than the first day of trial, the government shall provide the court with a tabbed binder containing copies of all the proposed government exhibits, corresponding to the government's filed exhibit list. 9, any change of plea must be taken prior to 5 p.m. on the last business day before trial is scheduled to begin. 10, any motion for a continuance of trial shall, which means it has to include whatever's listed here. Shall 1, set forth in detail which factors constitute grounds for continuance, including the complexity of the case, the security clearance process, and any anticipated impact of the Classified Information Procedures Act. Or like if you've been watching, whether it's social media or different news channels, if you hear CIPA, that's CIPA, or the Classified Information Procedures Act, because this is a case that concerns classified documents. And 2, indicate whether the reasons served by granting the continuance outweigh the defendant's constitutional and statutory rights to a speedy trial. It will. A lot of pundits are expecting that Trump's side will file some type of motion for a continuance. They'll have to do that before July 24th, according to this order, unless they file a motion for extension of time. Because part of this being a classified documents case and the CIPA process, people have to get clearance in order to see some of the evidence. And it's a process. So I'm sure it's going to be expedited or sped up so that, there is no delay, because yes, there is a constitutional right for all criminal defendants to a speedy trial. Trump also has the right to waive that right. Just like last week with the indictment, a criminal defendant, and this is also part of the Sixth Amendment, a criminal defendant has the right to have the charges read. And Trump waived, through his counsel, waived that right. So his side, they could try to, and they probably will try to delay it. I would imagine that they're going to try to have it dismissed. And then if that doesn't work, then they're going to try to have it delayed as long as possible. And there's been a lot of talk about why there really weren't conditions put on the former president when he was arraigned last week. Part of that is a strategy to remove reasons to file motions and delay the trial. The first was how people question, like, all this has been investigated in DC. Why is this being filed in Florida? Well, that's venue. Because if it's, the documents were in Florida, for the most part, except for that little bit where they were at Bedminster. But there don't appear to be any charges in the indictment related to Bedminster and what went on at Bedminster. It's talked about in the indictment, but there is no actual charge that I could see. And I could be wrong. If I'm wrong, just correct me in the comments. I'm okay with being wrong. But if this was filed in DC, then Trump's attorneys and Nautis attorneys, they could file a motion to change the venue, or a motion to dismiss, because the crimes didn't happen in DC, they happened in Florida. So having the grand jury indict in Florida, it just removes that from it just takes it out of play. And the same thing with not taking his passport, no travel restrictions, because if there had been travel restrictions, there's no doubt that his attorneys would file some type of motion that would have to be resolved before trial. So that could delay the trial. So it's a lot of these things were taken out of play before the defense had the opportunity to use them. So back to the order, paragraph 11. The filing by counsel of a notice of unavailability by motion or otherwise is not provided for under the local rules and shall not be presumed to modify or alter the court's scheduling order. So a notice of unavailability, it's something that the attorneys will file where, this we'll take this case, for example, that the trial term, it's a 2-week trial term starting August 14th. So you go August 14th to 14 days, August 28th. And one of the attorneys is, I'm not available on August 25th, 26th, 27th, 28th. And what they do is they file a notice of unavailability with the court, letting them know, like, hey, I'm not available on these dates. Um, and it sounds like paragraph 11 is the court telling counsel to make yourself available. Because we're not changing the date, so you better change yours. Paragraph 12, if any party seeks to introduce transcripts at the trial, that party shall exchange those transcripts with all counsel prior to calendar call. If a transcript cannot be agreed upon, each party shall be prepared to produce its own version for the trier of fact. And I know that the indictment references, it includes a couple transcripts of conversations. So if those transcripts are going to be introduced at trial, it's just, they got to get together. And as for the trier of fact, in this case, that's the jury. The jury is the trier of fact. Where's the second? Oh, okay. They forgot. Oh, there it is. All anticipated Jenks Act material shall be turned over to defense counsel no later than the morning of the first day of trial. The material shall include a face sheet for defense counsel to sign and date, acknowledging receipt. For purposes of the record, the signed face sheet must be filed by the government on case management or electronic filing no later than 7 days after the conclusion of the trial. 14, anybody need an interpreter? 15, this just says that, certain motions have to have a proposed order and the proposed orders must be filed as attachments. And that makes it easier for the judge. And usually whatever you're asking for in the motion, you put that in the proposed order so that way, you're looking at it as if the judge is going to grant your motion. So you prepare a proposed order that really all the judge just has to sign it and they're done. And it doesn't have to be the court actually preparing the order. Let's see. 16, pursuant to local rule 5.3 and consistent with the 11th Circuit's local rules and internal operating procedures, within 10 days of the conclusion of a trial or other proceeding, the parties must file electronic versions of documentary exhibits that the party offered or introduced into evidence, including properly labeled photographs of non-documentary physical exhibits. The parties are reminded to review each of the requirements set forth, including the requirement to redact certain information and to certify compliance with the local rules. 17, should it actually get to sentencing, meaning, if neither Trump nor Nauta enter a plea, and it actually goes to trial and the jury finds them both, one or both of them guilty, the next step would be sentencing, where there would be a sentencing hearing. So 17 talks about just what the deal is for, like, if it gets to a sentencing hearing and how that will be handled. And one of the things, what is it? 17C, the court has discretion not to consider the merits of untimely objections. So that's usually talking about, like, if something happens during court that either side disagrees with, they have to enter their objection right then and there so that it's on the record. Um, and they can't come back after the fact and try to, I mean, they could, but it's not a good look. Um, so, but all in all, this is a standard. It's a standard pretrial order. Like pretrial orders that are issued all over the country every single day. Um, so if there are any questions about the order, feel free to pop them in the comments. Um, and just because it has the trial term starting August 14th, that is not what's called the date certain, which means the actual trial date. They'll have the calendar call the week before, and they'll figure out, if any motions are filed. We're going to know a lot in the next 30 days, or we're going to learn a lot in the next 30 days, because the court order tells both sides, like, if you're going to file any pretrial motions, they need to be filed by July 24th, which is about roughly 30 days from now. So that's where we're going to see some, maneuvering, or we'll see some of, Trump and Naughta's defenses. Uh, I would certainly anticipate a motion to dismiss. Um, and then the judge will say, if there are motions filed, which, I mean, everybody's pretty much anticipating that there will be motion filed, that this is not going to go to trial in August, that there will be some type of delay. The judge will set a briefing schedule for any replies, because when a motion is filed, we'll say in this case, Trump's attorney files a motion to dismiss, and they lay out all the reasons why the case should be dismissed. The prosecution, they'll have a certain amount of time, and depending upon the local rules of the court, it could be 10 days, 20 days, 30 days, to file some type of response. And then the judge, like, it'll be set for a hearing. And that's just standard motion practice. There's nothing out of the ordinary so far. I mean, I know that there are people that are bitching because, Trump was fingerprinted electronically. He didn't have to get his hands dirty. People that are complaining that he was allowed to use his official portrait instead of having a mugshot taken. He wasn't handcuffed. The concessions that were made, with the terms of his being released, because there are other people that have been charged under the Espionage Act who had to sit in jail waiting for their trial date, that they had to surrender their passports, that, they had restrictions. So there are people, complaining that Trump doesn't have any of these restrictions. The only restriction that he has is that he can't talk to any other defendant or the witnesses about the case. And as a personal side note, does anybody have duct tape that will fit over that man's mouth? I would imagine that his attorneys have told him anything he says publicly about the case or his involvement, it can be used against him. That interview that he did on Fox last night, that can be played in court. He has the choice whether or not he wants to actually testify if this goes to trial or when this goes to trial. the prosecution can use any interview he gives, his whatever they're called on Truth Social, anything that he puts out publicly. It's like when somebody gets arrested, it's like you have the right to remain silent. Anything you say can and will be used against you in a court of law. Yes. So on a my feelings about Trump really, like, they don't matter. But just as somebody that loves the law and court and and all that sort of thing, it's he's snitching. He's making the prosecution's case easy. Um, he needs people around him to tell him to shut it. Um, he has plenty of other things to talk about. He does not need to talk about this case. He does not need to talk about the documents. Um, if he did this and there's evidence that he did this, then he's just like everybody else that gets charged with a crime where there's evidence that somebody committed a crime. Um, there's a lot of two-tiered justice system going around, and I would agree that there is a two-tiered justice system, that there is one tier of justice for the rich and powerful, and there is another tier of justice for those who are not. Um, it's not a red and blue thing or a Democrat Republican thing. Um, where Trump was indicted it's a very conservative area. So the presumption is that these are Republicans, or mostly Republicans, that indicted him. Where the trial is going to be held is a highly conservative area. Um, so that means that the jury pool is going to be primarily conservatives. Um, and I've also heard or seen floating around where it's oh, well, if they get a bunch of Trump supporters, that's an unfair statement. Um, when a person is named as a juror in any court, you take an oath that you're going to put all of that aside, all of your bias, your belief, like, you put it all aside, because the only thing that you concern yourself with, or are to concern yourself with, is the law and the evidence that's presented to you during the trial. Um, so it's unfair to presume that just because somebody is conservative, that they would vote to acquit Trump. Just like it's unfair to say that someone that's a Democrat would vote to convict him. It People that are jurors, they take that seriously. They take that oath seriously. Because if they don't, they usually find themselves kicked off the jury, because there's some type of jury misconduct. But 99.9% of the time, or the majority of the time, however you want to phrase it, the people on juries, it means something. I mean, it's a civic duty. It is a solemn oath. And they take it seriously. So, I mean, and it's the same thing when somebody takes an oath to uphold and defend the Constitution because they're some type of public servant. Um, how they vote in their personal life usually has no bearing on their professional life. So, seeing that it's, a Bush appointed judge, an Obama appointed judge, somehow implying that, oh, this judge is gonna, rule this way because Obama appointed them and he's liberal. No, judges also take oaths to be impartial, and to put aside their bias. So it's it's unfair to presume that just because somebody is conservative or just because somebody is liberal, that they're going to vote a certain way, rule a certain way. It's unfair. Um, and it's not something that I engage in. So, the other podcasters, independent journalists, media people that, are trying to get clicks and likes and, add money and all that kind of stuff, they can go ahead with their negativity because, it does sell, but that's not, it's not who I am, and it's not who, or it's not what I want this podcast to be. I realize that I'm just an ordinary citizen, just like the people that watch. Um, I'm not a celebrity. I'm not trying to be a celebrity. I'm trying to bridge the divide and just try to see what I can do to, you know, get us back to where we used to be able to speak to one another, have debates, um, without the Rethuglicans and the, demon rats and, um, we used to be able to do that. I mean, there are people that I've known my entire life that in these last 7 years, um, I actually had somebody call me an enemy of America, somebody that I've been close to for over 40 years, um, because I'm a Democrat, because I'm liberal. When to me, liberal just means that I want everybody to have the same rights and freedoms as everybody else. Um, and I would love to get away from that. Um, so if there are any questions about anything having to do with the indictment, the arraignment, any of the orders that are issued, feel free to put them in the comments. I will do my best to answer them. Um, and well, I'm not an attorney. I'm not going to give legal advice, uh, but I am a paralegal. I've been a paralegal since 1997. So I'm familiar in that sense. I'm familiar with the law in that practical sense of actually being in court, um, typing the motions for attorney review, having to learn the court rules. So it's not legal advice. It is based on my over 20 years experience, um, as a paralegal. But again, it's not legal advice. Also today in the news, sorry, we had Hunter Biden. It's been reported that he is going to, or he's pleading guilty to 2 misdemeanor tax crimes for failing to pay taxes timely. Um, and there was a plea agreement entered on that. And that's been submitted to the judge. The judge will review it and either approve it or say, or reject it. And it's my understanding from the reporting that I've seen and the research that I've done that, Hunter Biden, he did pay the back taxes and the penalties. So like he's not sitting there owing taxes, they are paid. And then there is also a gun charge where he filled out like an ATF form incorrectly, um, where it asked if he was a drug user or a drug addict. He put no, and at the time he was. So that that gun charge is under a pretrial diversion agreement. Um, and that's just going to be that if whatever the terms of that agreement are, if he follows those, then he'll either he'll be done. Um, it's going to depend on what the terms of that agreement are. Um, as well as the plea agreement. So there's two separate agreements. The plea agreement as to the tax charges, which were misdemeanors, which means that most likely we won't have any jail time, and then a pretrial diversion agreement as to filling out the form incorrectly. And I've seen a lot of people flipping out that, again, 2 tiers of justice, that, he's the president's son. He got off with a slap on the wrist and this sweetheart deal. In my opinion, there is a 2-tier justice system for the rich and for the not rich. Nobody's mentioning that a sitting president absolutely 100% has the power to pardon for any reason at any time. You can't appeal it. You can't take them to court over it. It's one of the things that, I mean, it's absolute. And, for everybody screaming that, Hunter he's getting this slap on the wrist, he's still facing consequences. And, from everything that I'm seeing, one of the examples that's come up today is Roger Stone, that Roger Stone owed more in back taxes than what Hunter owed. And Roger Stone, there was no criminal charge, that it was civil, that he was allowed to pay a fine and blah blah, you're done. So he wasn't even charged. And the checking the wrong box, I mean, at the time, yeah, he did wrong. If the DOJ, if they turned around and decided they were going to hammer him over this, and it fit the the facts of that law, sure, I mean, go ahead. I have an issue with all this, Hunter. Hunter is a private citizen. He's a private citizen. Yes, I understand he is the son of a sitting president, but he's just a private citizen. It's like everybody calling for the government, federal law enforcement to come after me, come after you. Like, we're citizens, and that's all Hunter is. I don't like that aspect of it, that everybody is, their hair is on fire to, put the full weight of the government and just beat the shit out of Hunter, who's a private citizen. He's never held government office. And he's been through a bad few years. If you've never loved someone who's an addict, it's not easy. It's not fun. And he did some dumb shit when he was on drugs. Just like how many millions of other people every single day. Biden has the power to pardon, and he hasn't. He's letting his son, he's letting the rule of law take its course. We're talking about 2 misdemeanors. He paid his back taxes, he paid the penalties, so once that's done, there's really no damage to the government. It's been taken care of. You know, this 2 tiers of justice, and, like, Biden could have pardoned his kid, and he's not. So for people that are talking about, like, "Oh, Biden weaponization of government," like, if it was Biden's DOJ, I mean, and for all intents and purposes, like, yeah, it's the administration's federal law enforcement. Um, but Biden's not getting involved in Hunter's case. He's not getting involved in Trump's case. He's letting the DOJ, the FBI, the whoever it is working on these investigations, they're doing their thing. You know, there are like it's not common to see like what's going on with Hunter. It's not out of the norm. Well, hi, Patrick's time. Welcome. Um, this is the first time a sitting president's DOJ has indicted his chief political rival in an upcoming election. That that's accurate. I I could push back a little bit. Because we could have seen Nixon be indicted if Ford didn't pardon him before everything else went down. So yeah, I mean, this is the first time. I have also questioned why Trump entered the 2024 race when he did. Was it so that he would have this argument that I'm a political rival? Trump also ran on lock her up. Well, no, Nixon was getting kicked out of. He'd just been kicked out of office. Trump ran on lock her up. He ran in 2016 on pursuing charges against Hillary Clinton, who was his chief political rival in that election. So if we're going to call it out for one, then like I'm looking for fairness. That if it's not cool for one, then it's not cool for the other. And with people ragging about how charges weren't brought up against Hillary, that was Trump's DOJ. That was Trump's FBI. He had every opportunity, and if there were crimes that she committed that they could prove in court and they were supported by evidence, then even as a Democrat, they should. I will happily say they should have charged her. They should charge anyone where they can. Let's see. Trump never weaponized the DOJ prosecuting his opponents. But is it weaponizing the DOJ if there's evidence of a crime? If there was evidence that Hillary committed a crime, then she should have been charged. Because the rule of law is the rule of law. I mean, and this is, of course, my opinion. Your opinion is just as valid. Well, yeah, Comey came out right before the election, but that doesn't stop Trump once he's in office from directing that another, having a special prosecutor appointed. I mean, Comey's FBI. It's for the DOJ. You know what? Comey can get bent. Um, yeah, it's got nothing to like. It doesn't stop Trump from having DOJ. Like FBI doesn't take precedence over the DOJ. Like DOJ still could have gone after her and done an investigation. And like I'm all for, if I don't care who they are. I don't care about their political party. I don't care. If they committed crimes and you've got evidence, and charge them. Absolutely charge them. I don't care who it is. I don't care what time of year it is. Cuz if what's in the indictment against Trump is accurate, and we'll take Trump's name off of it. If that was if that was, put any name on it, put Biden on it, put Obama on it, you know, I don't care who it is. Whoever did that, they should be charged. And Trump never having his political opponents investigated, well, that sounds like a failure on Trump's part. Because if you had evidence, and you're presented with evidence, I mean, yeah, I'll give it to you. Like, don't take the person, that it's, oh, I don't, you know what, I don't like Trump, so let's just investigate the shit out of him until we find something. No, I don't agree with that. But if somebody has evidence that a person committed a crime, then whoever that person is, they should be investigated. And if that evidence is corroborated, then they should be charged. So, just because Comey said what he said about Hillary, that didn't, like, if especially for as much as he yelled, lock her up, like, explain Trump's crime as I see it. Well, I will do that. That is, I have no problem doing that. And I appreciate all your comments. Thank you very much. Um, I'm going to start off by saying that it doesn't matter how I see it. What matters is what is in the indictment and what can be proved in court. And that's going to depend on whether or not, oh, we'll get to Pence and Biden. And that depends on, whether all of the evidence is going to be able to be presented at trial, because there are some maneuverings that can go on in trial. And I'm going to say off the top that I don't like anyone having classified documents that are just out in the universe. I don't like it. At the same time, accidents happen. If you have somebody packing shit up for you and it was in a stack, I can see where it happens. And I can understand why in other cases, where it's, oh shit, I didn't realize I had this. Here, take it. I didn't mean to have it. Or where it's accidental, where DOJ decides not to prosecute. I get it. But then I also get where it's someone that's not supposed to have them. Like, I mean, it depends on the facts of the case. So my take on the Trump case is what's outlined in the indictment. Um, and that is that as of January 20th, 2021, he was no longer it is he was no longer president. So his power to classify, declassify, um, ended at that point. And also, according to the Presidential Records Act, as of noon, January 20th, 2021, all presidential records became the property of the National Archives. And presidential records are records that are generated for the president to do his job. Vice presidential records are treated the same as presidential records under the Presidential Records Act, um, which was amended in 2014 to include vice presidential records. As far as Congress people, whether they're in the House or the Senate, no, they shouldn't have classified documents. But as far as their papers that they gather through their time, whether it's in the House or the Senate, that they're allowed to keep those. Many will donate their papers to colleges or different type of, their alma maters, that sort of thing. It's not an uncommon thing. But back to Trump. So as of January 20th, 2021 at noon, all of his presidential records were to be under the care, custody, and control of the National Archives. Anything that he wanted, like, to be a personal record that may have been considered a presidential record, that was to be done during his term. So that was to be done before noon, January 20th, 2021. And that apparently that didn't happen. I'm not suggesting, nor do I believe that, no, a crime against the whole purpose of the Presidential Records Act was to stop presidents from, like, having shit they're not supposed to have. It was put in place after Nixon, because of the stuff that Nixon tried to pull. I'm not suggesting that the president or the former president knew that he had classified documents and intentionally moved them to Mar-a-Lago. Just that as of January 20th, 2021, he was not supposed to have any presidential records. I'm not outraged. Do I look? I'm not screaming and hollering. And National Archives asked for the presidential records back because they're supposed to be with the National Archives. Some of them were returned at that time. And then somewhere it was reported that there were more documents. So National Archives asked again. And this is the part where Trump's talking to one of his former attorneys about, like, what if we just don't give them back, or, what if we just disappear them? That sort of, and I'm paraphrasing, to the point where National Archives went to have a subpoena issued, and a subpoena was issued. A subpoena is issued by the judge. It's not something that you can just pull out of thin air. You have to show cause. You're one question at a time. you know, and he defied the subpoena, according to the indictment, that he had his staff at Mar-a-Lago move boxes of documents that contained presidential records, contained classified documents. Some of them are highly classified documents. and had them moved around and then represented to his attorney that like, "Oh, no, this is everything." Um, so the attorney filled out a false certification, and that's where the conspiracy and the obstruction and the false certification charges come in. Um, I I'm not one that's sitting here going, "Trump was indicted." It it hurts to have a like, it kills me, like, well, I mean, you can tell from the headings. I mean, it lays it out in the indictment, just a general sense of what a general description of what the document is. Um, I don't think anyone should have classified documents that isn't supposed to have them. Um, and the part of the Espionage Act that most of these charges are under, the 31 charges, it talks about the willful retention. So willful retention is you're you're not supposed to have them. You were asked for them and you said, "Suck it, I'm not giving them back." So that's willful retention. And yeah, his attorneys, they're going to go into court and they're going to argue, whether they were. I mean, there is language in the indictment where he says that he didn't, at least one of the documents, he didn't declassify it before he left office, and now he can't. So, if that's an accurate statement that he made, then he's admitting that he understands how classified documents work, how declassifying documents work, that he didn't do that, which means that he's admitting that he's in possession of classified documents. And I don't care who it is that, like, it does not matter to me that it's Trump. If this was any other person that did the same thing and was given these same charges, okay. Like, it's upsetting to me that a former president was charged with this, because no one who sits in that chair, like like that's an honor to be put in that chair. And someone that's in that chair shouldn't be that reckless with our national secrets. And I mean, I get why Pence and Biden, throughout the course of their vice presidencies, why they would get classified documents. If they're, I they're second, they're second in line to the presidency, so I would imagine that they have the highest clearances, that they have to be aware of everything that the president is aware of, just in case they're made president. And but the issue with Biden and Pence, it's that willful retention. Like, when all this stuff went down with the, executing the search warrant on Trump and all these documents, like, Pence and Biden's people, they they went and looked and found, like, "Oh shit, we have classified documents too." I believe Pence called the FBI, notified the FBI or his people. Biden's people notified the DOJ. Um, Pence has been investigated. It's not necessarily like, if you have them by accident and you return them immediately and there was no harm, like the information didn't get out, it wasn't shown to anyone, those secrets are safe. I can understand why Pence isn't being charged with anything. Um, well, you know what? This isn't just a process crime. It's it's about our country's security. If Trump really did show some of these like military plans, or like our military information to other people, like that stuff all has to be redone. I don't like. I'm not a fan of Pence personally. But as far as Biden, if if he broke laws with the classified docs that were in his possession, do I believe which Trump dossier? The Steele dossier? Not it. Some of it just sounds stupid. Um, if Trump is a Russian agent, I don't think he's an intentional Russian agent where he's where he knows he's a Russian agent. I think he runs his mouth too much. Um, he's arrogant and he's cocky. And he thinks he can just do whatever and say whatever. And he's always been that way. Um, just like he's doing now, being on all these, on Fox and CNN and all these different news shows, running his mouth about this case. He's somebody that runs his mouth and he doesn't know when to shut up. Um, it wouldn't surprise me if he ran his mouth to Putin or an oligarch or, somebody from Russia and gave him information they weren't supposed to have. Um, it wouldn't surprise me. I mean, but I'm somebody that I want to see the evidence. I'm not going to jump up and down like with just all this stuff that's going on. Um, like with the alleged bribery scheme. I want to see evidence, and then if there's evidence, handle it. Charge him. I'm not going to jump up and down and scream no way. Like it doesn't matter whether I like Biden or not. If he committed a crime, charge him. I'm not so much worried about Biden telling secrets because he's running his mouth. Biden is more misspeaking because he stutters and he slurs his words, and he's on the old side. I think he means well. But yeah, with him, I'm not worried about him spilling secrets. I'm just worried about just words that come out of his mouth. I'm not a fan of Kamala Harris. Well, we're debating right now. So I've just proved that point wrong. And Trump's not in jail. So, I mean, if he committed a crime, and we're talking about national defense information. Like, would you want any president that is reckless about national defense? Okay, well, Peter Hodes doesn't have to. He doesn't have to debate. He's a private citizen, and one of the things that. Well, no, I mean Oh Jesus, he's got the data. The problem is people that aren't debating in good faith. That's the real that's that's one of the issues why you don't see a lot of debate, because there are some people that they don't debate in good faith. That it's, you know, here's your question, here's the evidence to respond to your question, and then it's, well, what about this? And then it's constantly moving the goalpost. Um, so there is some, disingenuousness when it comes to debates. If there was somebody that was willing to debate in good faith, then, you know, then yeah, they should, because it's a good faith debate. I'm not a fan of, the what about? Well, what about? Well, what about? Well, what about? Well, we could do that all day. Nobody's nobody's advocating. Wait a minute. What kind of mandates? Are you talking about mask mandates or vaccine? And I want people to stop calling the COVID vaccine a vaccine. Um, it may have at one point had the opportunity to be a vaccine if more people got it. Um, but it's more like a flu shot. It's a COVID shot. It's because it really does the same shit that the flu shot does. It doesn't stop you from getting the flu. It just lowers the intensity. And that's really all the COVID shot does. Um, well, I believe in fairness. Whatever rights I have, you have. And I'll be specific, Patrick. I am speaking specifically about you. That whatever rights I have, you have. And I just as I would fight for my rights, I would also fight for yours. Because if somebody can take away your rights, they can take away my rights. And one of my rights as an American citizen is I have the right to extend my left arm or my right arm, whichever. I can point it straight out. My right to do that ends at the tip of your nose. And you have that same right. And your right ends at the tip of my nose. And if we're standing there facing each other and we both have our left arms out, well, that is a perfect world because we are both fully exercising our rights as American citizens and human beings. We are not infringing on one another's rights. It's absolutely perfect world. But then let's say both of us want to move our left arm to the right, that I want to move my arm this way, which means that you're going to move your arm that way. Well, we can't because we're going to hit each other. Our rights and freedoms are going to bump up against one another. And in the instances where that happens, I fully believe that there has to be compromise. There has to be some type of voluntary compromise between you and I so that we can agree how we're each going to move our arms to the right, which we have the right to do, without infringing on the other's right, without damaging the other. Like I wouldn't have the right to like throat punch you to get you out of the way so that I can move my arm, and vice versa. You wouldn't be able, to like kick me in the face, um, or wherever to get me to move, to move so that you can move your arm. We would have to agree to a compromise. Either one of us voluntarily backs up so that there's room for us to, our arms to clear each other, or, we mutually, you take 2 steps back, I take 2 steps back so that, I'm not giving up more than you are. You aren't giving up more than I am. It's equal. It's fair. And, but there has to be compromise. And one of the things that I don't have the right to do is make you sick. I don't have the right to give you an illness that at the time was just straight killing people, overwhelming our resources, overwhelming our healthcare, our doctors, our first responders. I don't have the right to do that. I mean, and this isn't anything new. Um, I mean, this no, I don't have to assume that you're sick. I'm saying if I'm sick, I don't have the right to get you sick. You don't have the right to get me sick. You can look at the Spanish flu when everybody and their mother was wearing a mask. You can even look at the AIDS epidemic, because if somebody with AIDS who knew they had AIDS went out and had sex with someone, or, bled on them, like, because it could be transferred through fluids or your blood, that that person with AIDS could and was charged with attempted murder, because you don't have the right to get somebody else sick. It's why you have so many, or it's one of the reasons why there are product disclosures with different, if it's cancer causing, like, you can't just go, hey, I made this thing, but it causes cancer, and I'm not going to tell anybody. Like, we don't have the rights to just make, well, California's California. And that law has probably changed, because HIV is different than AIDS. Initially, it was people were getting AIDS, and then as it started to, be combated, it was more the HIV, and that if you didn't take care of it, it could become AIDS. But HIV is not necessarily a death sentence. AIDS was a death sentence. Like, there was no cure for it. There was no medication for it. If you got AIDS, you died. So that's why people were charged with attempted murder. But the point is that I don't have the right to get you sick. You don't have the right to get me sick. At the time, when COVID was first a thing, they didn't have all the information that they needed on it. All they knew was that people were dying. So if I have to wear a piece of material on my face to and really just for as long as it takes me to be in a grocery store, or to walk, to walk a few feet, because I wasn't one of the people that was wearing a mask in a car by myself. If I was outside, just out in the open, then no, I wasn't wearing a mask. But if I was going to be around people, then I was absolutely fine, like, wearing a square of fabric is no big deal, because I know that if I had COVID and didn't realize I had COVID and gave it to somebody who died from it, like, I would feel ridiculous. I would feel horrible, all because I didn't want to wear a square of fabric on my face for the 10 minutes or the 15 minutes I'm going to be in the store. Like, that was no big deal to me. social distancing. What it was no big deal. I mean, it was like just like the Spanish flu all over again. And if everyone had just taken it for what it was, and I mean, there were so many different things that could have been done differently. And if you think it's ridiculous, I mean, that's fine. You're allowed. But it's the same thing as wearing a scarf in the winter and covering your mouth with the scarf. It's the same thing. If you ride a motorcycle, no, I'm not. If you ride a motorcycle, you're wearing a neck gaiter or a bandana most of the time, most of the people, because you don't want to catch bugs in your teeth. Like I care about people, and I'm not sorry for that. I'm not ashamed of that. It's not a bad thing to care about people. I'll take. Well, see, all studies show the mask doesn't prevent transmission. Not all. And it would depend on where we were. Was it the original COVID? Was it one of the variants? What type of mask? I mean, nothing is 100%. I don't care if it reduced the risk by 1% or 1/10 of 1%. Wearing a mask was not a big deal to me. Doctors wear masks every day. If you're spray painting or plastering or doing, oh, what is it called? Um like on the lathe, if you're doing like woodworking and you're kicking up a ton of like dust and shit, you're gonna put a mask on or a rebreather. So I mean, it's what's the big deal? If putting a mask on helped in any way, I was fine with it. How many shots? I had 2. I had I mean, I waited, um, before I got any of them, because I just wanted to I wanted to see. I didn't just go like, "Ooh, shot, let me go get it." No, I waited. Um, and I did get I got 2, so I haven't had, I want to say like 3 or 4 or like a couple booster. I didn't get any of like the boosters. Um, I probably won't. I do not regret taking them. Because it really didn't. I mean, I had a little bit of a reaction to the first one, but nothing. I was just exhausted after probably about 20 minutes after taking 20 minutes to a half hour after taking the first one. Um, One, my arm just throbbed, which was like that was a little freaky because it was you could feel it moving. Um, that it was just like a little bit, and then as it spread. Um, so that was a little weird, and then I was just exhausted. I face planted, and I think I slept for like 6 hours, in the middle of the day, and um but then once I woke up, like, I wasn't tired, I never got feverish. It was just, and then it was just a few days that my, what's it called? My arm was sore. And then when I had the second one, which I think was like a few months later, uh, it was nothing. Like, I I had no pain in my arm. I wasn't tired. I really had no reaction to the second one, um, which was great because I was traveling. Um, I mean, and that was another thing during the like I traveled as much as I could wherever we were. Like I went to Florida, I went to Ohio. I didn't sit, you know, I didn't stay home. I took precautions where they were needed or just to be on the like I'll err on the side of caution. I will I'm okay with erring on the side of caution. Okay, so survival rate, we'll just say that there was a 1% death rate. There's what, 325 million people in the country? 1% is like 3.2 million people. 3.2 million people. Right. Okay. I I can't do that kind of math in my head. Like, so I mean you're okay, you're looking at most 3.2 million people ish. I mean it wasn't like it was, oh, there's a chance that maybe like, 10,000 people might die out of 325 million. When you start getting up into the million people or the 2 million people as a chance, because at the time we didn't know. I mean, it wasn't something that you could just, hey, everybody just do what you're doing and we'll figure it out. Like if we'd taken it seriously, and that was the real shame, that it was not taken seriously. We may not have had to have the shutdown and all that nonsense. You know, if no one was going around saying, "Oh, it's a hoax," and we'll get rid of it. But then taking no steps to actually do that. A virus, its job is to eat, and it's going to eat until it runs out of food. And the longer it has to eat, the more of a chance that it has to mutate. It was not a hoax. It wasn't. And oops. Like, no. I mean, I'm still here, so there's no 5G or any of that other stuff. Like if people, if it's okay to take a flu shot, and like I really haven't been sick since, so I'm okay with it. I'm okay with helping people out, and I'm not judging people that choose otherwise. Would it have been nice to not have to deal like with the shutdown? Yeah, because I had plans. I had things that I was doing, things that I wanted to do. 'Cause 'cause I had plans. I had things that I was doing, things that I wanted to do. 'Cause 'cause I had plans. I had things that I was doing, things that I wanted to do. 'Cause 'cause I had plans. I had things that I was doing, things that I wanted to do. 'Cause 'cause I had plans. I had things that I wanted to do. Things that I wanted to do. that got totally dicked because of the shutdown. You know, and we had to have a shutdown because people didn't want to put a mask on to walk around in a store. You could breathe just fine. Stop calling it the vaccine. I would completely disagree that that it's a vaccine. Vaccine stops a disease. This doesn't. The only thing that it does is that it lowered your symptoms. Like everybody that I know that had the vaccine that ended up with COVID, it was mild. I had friends who got the original COVID that were down for the count for 6 weeks. Couldn't walk from their bed to the bathroom that was in their bedroom or just off of their bedroom. You know, and like I personally didn't have anybody die, but I have friends that lost people where it was like the original COVID. I wasn't vaccinated. I wasn't shedding on anybody. I wasn't when I got the shots at that point, like I wasn't going anywhere. I was actually traveling before I got the shots. You know, but I mean, again, I don't have a problem wearing a mask. I didn't have a problem, with this. I I I I I mean, I understood why they were talking about the 6 feet of like the separation and stuff, but like I thought that was just like stupid. If it's 2 seconds that you're passing somebody in a shopping cart, like in a shopping aisle, like who gives a shit? Well, I'm very sorry that you lost people. Did the people that you lost, like had they taken the shot or had they not taken the shot and then they got it from somebody who had, is that what you're saying? um yeah, I thought the social distancing was dumb. It was very, very dumb. Um what's it called? But I'm coming up on right now I can only do live streams like 2 hours at a time. I'm coming up on the 2-hour mark. But if there are subjects that you would like, or if anyone would like to go over for a future episode, I'm down to talk about anything. I don't care, because that's the whole point, is to just talk to one another, and not, without judgment, without being dicks to each other. Get back to having actual conversations as human beings. So I would like to thank everyone that has joined. Patrick, you have been awesome. I've appreciated our conversation, that you didn't cuss me out at any point. Thank you very much. I got the shot and I don't have myocarditis either. What's it called? But I get what you're saying. So I appreciate everyone that has joined in, whether live or on the replay. If you would like to help support the channel, there are links in the description, links in the chat. I appreciate every like, comment, subscription. I appreciate you all. And I just want to thank everybody for joining, and I'll see you next time.